Hello.
And welcome to the Hildebrand Law Firm topic for today.
Today we are going to be discussing a lot of really important things. I'm Kirsten Hildebrand,
And I'm Matt Kaplan.
and we are going to talk about a very interesting part of estate planning. So, when we're talking about estate planning, a lot of times we are not thinking about the fact that we want to protect not only ourselves, but also our beneficiaries.
So, protecting beneficiaries, I guess, help me understand. I'm already giving money to them. I'm protecting it for myself so that anything happens to me, it all goes to them. When you're talking about protecting them, how can I protect them from beyond the grave?
Yeah, that's a great question. And so, why don't we talk about something that's not protecting them, and then you'll get an idea of what protecting them actually is. So, let's suppose that you decide that you're going to set up a payable on death account. So, essentially, what that means is you go to the bank, and when they say, "Who do you want the beneficiary to be?" and you say, "I want it to be payable on death to my child." Well, that's all fine and dandy, except for what if, and then we can come up with 100 scenarios. What if the day before I pass away, my child got into a terrible car accident? That is my child's fault. And now the money that is in that account that's going to be payable on death has absolutely no protection. It just goes straight to the child, and then it's going to go straight out to whatever liability that there might be.
Right. And what's interesting too, payable on death, but still I get a lot of people that tell me, "Oh, my banker told me to set it up, make them an authorized user on the account, make it a joint account," all of these different things. I guess for a joint account, my biggest issue with having a joint account, having, whether it be a son on there, a grandson, a granddaughter, something like that, my biggest issue is that people don't care about your money like you do. And
Mm.
if they're joint on the account, not only do they not care about your money like you do, but then you add another chance of these issues popping up. That's another person who could get sued, another person who can file for bankruptcy, another person who could have these spending issues that we talk about.
Yeah, that's exactly right. So, what you're saying is basically if I put my child on the joint account and my child decides to have a wild night at Potawatomi and all of a sudden they have a massive debt, that joint account is truly owned by both of us. And that creditor is going to consider that to be an available asset that can be gone after. And so now my money that I put in there is really going to go towards his debt. Is that what you're saying?
Exactly. And not only the one wild night, what if your child has an instance of having many wild nights
Oh,
at many casinos or many places, and then says, "Oh crap, I need a fresh start. I'm going to file for bankruptcy." Do you think just because your
mm,
name is also on that account that account is safe from bankruptcy?
no way.
No way, no
Mm-mm.
way it isn't. So then all of a sudden, you've taken all of your money, and then to make things easier by putting your kid's name on the account, you've now opened up yourself for all of the liability that your kid has incurred.
Exactly. And, we always think, well, my child is very responsible. I have great people in my family. I don't have anything to worry about. But I just had a story come in where somebody was driving their car and they had a seizure. And it was the first time they had a seizure and they had a terrible car accident. But in that state, they are liable. So now, if they were on a joint bank account, say with me, that money is now available. So again, it's not just looking at the character of the people that you're putting on the joint bank account with, but it's also just considering it's a totally different person who could potentially have all of these other issues.
Right, and then one of the final issues that I want to talk about with this is, unfortunately, we've talked about it in previous ones, addiction.
Mm,
Addictions happen, and it doesn't have to be drugs or alcohol. It can be gambling addiction, shopping addiction. There's a whole lot of addictions out there, and the worst part about addictions is that in order to make sure that the problem doesn't go away and gets worse, what should you add to it? More money. And so
right.
the big problem is that you pass away. Let's say you relied on these joint accounts, or let's say you even did a fine job and you have designated beneficiaries on these accounts, and you say, "Okay, my son is my designated beneficiary. At least I did that, so this account's not going to go through probate." Which you're right, most likely it'll not go through probate. Your son's a designated beneficiary, great. The problem is that account and that institution, they're going to write your son a check, no questions asked. They don't care if your son has horrible sports addiction and is doing 20 leg parlays every weekend on NFL teams.
Wow, sounds like you know a lot about that.
I have a lot of friends that have that issue.
Okay.
They don't care if your son is addicted to opiates, like a lot of people are. They don't care if your son's an alcoholic. They don't care if your son has a shopping addiction. They don't care. They're writing your son a check, no questions asked. And that's a giant problem. And people like that should not have direct access to that kind of money because it's going to go in their pocket and it's only going to exacerbate the problem.
Yeah, that's absolutely true. And actually, maybe on a, say, less dramatic scale, but equally as interesting, is the fact that if you make somebody a designated beneficiary on an account, a lot of times you think, okay, well, that'll help me get the money straight to my kid without having, or my beneficiaries without having to worry about creditors for me. And so maybe there's situations where I would want that to happen. Well, what is happening is, let's just say banks have a lot of control in the legislature and they just seem to be able to always have things happening their way. One of the elements is that they don't want other creditors. Let's take, for example, the ambulance ride to the hospital that is private pay that resulted in mom passing away. So if the main account is now a payable on death to the children, and that happens, the kids rush in there the day after mom passes away and they're signing documents. We want this to go straight into our accounts. And this was more effective several years ago. But more recently, what we are seeing is that the banks are saying, hold the phone. We are not really willing to honor this payable on death until we know for certain that the creditors are not going to be left out in the cold. And so what they're requiring is that you go to the court and get a piece of paper, they call it. Well, we know that that's letters of administration, which means that you have to open up a probate. And so then by opening up a probate, there is a required notice to creditors that occurs. And so now the ambulance company that has the $2,000 charge is not going to be left unpaid. In fact, they will get paid through the funds that are in that account. So all of that to say, the best laid plans do not necessarily result in what you think is going to be an end run around those debts that may come in at the, in the last several events.
And a wonderful way to try to avoid any of this, take out all of this uncertainty, is with some good estate planning. There are some wonderful provisions that we can include in a trust in which whoever you want to leave your funds to, if you want to leave it to your one child, if you want to leave it to grandchildren, if you want to leave it to nieces and nephews, whoever you want to leave it to, they will have their own section built into the document. And what that section will say is that the money goes to them if and only if it can. And how do we determine if it can? That's for you to determine. You determine when that happens. I say I want it to happen when they turn 25, and as long as they're not going through any of these issues that we talked about. However, if they are, great. The section in the trust says that money stays there until all of those storm clouds blow over. If they're going through a divorce at the time of my passing, darn right that money's staying there. If they're going through a bankruptcy, if they're in a nursing home, if they're in an addiction, they have any of these issues, that whoever is the new trustee, that new trustee is saying, money's staying there. Once they can take that money, then I will give it to them.
Well, and that is so important to recognize, though, that the detail of your trust and the drafting expertise of your trust that show up in the document itself is what's going to determine the outcomes. So let me give you an example. I had a client who came in and the firm was actually representing her in a divorce action. Her father passed away and her father's house was in a trust in his name. And the husband of 20 years decided to go and file for divorce. And he got a good divorce attorney who immediately tried to get 50% of dad's house to be part of the division, or rather 100% of the house to be part of the division, so that 50% of the value of the house would go to him, 50% of the house would go to her. Well, when I told her that the attorney was trying to make this happen, she said, wait just a minute. That house is in a trust, and my dad told me that it was protected as long as it was in a trust. And I said, well, let me take a look at the document. I read through the document, and there were the specific provisions that Matt, you just referred to, were not in there. And because it was not laid out in that way, an enterprising and thoughtful divorce attorney on the other side was able to pierce through that trust and make a good argument that 50% of the house, dad's house, now belonged to the husband as part of the marital estate and not part of wrapped in dad's trust. So that's why, again, to have a crummy trust, a crappy trust drafted up and think that it's going to do all of these wonderful protections is just patently false. And I think that's what is so important to understand, that buying a trust is like saying I bought a car. Well, that can mean anything in four wheels.
Right.
And it can mean that it's a rust bucket with a terrible engine and hardly goes at all and breaks down. Or it can mean a well-functioning, excellent car that is going to take you the distance, that's going to protect you. So we at Hildebrand Law Firm, we draft trusts so that they fulfill what your desires and your goals are, and it keeps it simple and it keeps that protection in place. So that's why we are really here for you to protect your family and you both today and tomorrow. Thanks so much for joining us.